Okay, let's dive right in. The situation with the 79th Group. Well, it's escalated. It's really looking like a serious financial collapse now.
It really is. We're seeing multiple companies hitting administration, and honestly, more seem likely to follow.
And the big concern, the reason we're doing this deep dive, is that many of you holding loan notes might not grasp just how serious this is for your investment.
That's precisely it. The ground has shifted. What might have felt secure before, well, the administration process changes things dramatically.
So our mission today is basically to cut through all the legal noise. We want to explain what these recent court actions mean, what's likely coming next, and really focus on what you can actually do now.
Yeah, practical steps, not just theory. We're looking at the latest court updates, official filings, and analyzing what that means for investors.
Right, so let's start with the courts. What exactly has been happening? It seems like a flurry of activity.
It has. Okay, first up, 79th Luxury Living 6 Limited. Insolvency Law filed a winding up petition on April 15th, 2025.
Winding up, so trying to shut it down completely.
Initially, yes, but almost straight away, the very next day, actually, Grant Thornton were appointed as administrators. That's Stephen Cave and Gareth Latimer now managing that process.
So administration overrides the winding up attempt.
In this case, yeah, the administration route was favored. Now, 79th Luxury Living 5 Limited. That one's a bit different, isn't it?
Slightly, yes. There, a low note holder, someone owed £30,000. They started the winding up petition first, back on April 10th.
Okay. And Insolvency Law supported that action. But then another investor, using their own solicitor, pushed for administration instead.
Ah, okay. So a bit of a pull in different directions.
Exactly. And the court has appointed interim receivers for now, just to, hold the fort and protect assets while things get sorted out properly before full administrators might step in.
Right, interim receivers, got it.
Okay.
And the third one we're tracking closely, 79th Commercial 3 Limited.
Similar story there in some ways. Insolvency Law initiated winding up proceedings, again on April 15th. But then, just 2 days later, a different loan note holder filed for administration. So again, we have interim receivers appointed, and it's heading down the administration path.
So 3 major entities already in formal proceedings. And you mentioned this might just be the start.
All the signs point that way, unfortunately. We're hearing and seeing filings that directors of other 79th Group companies are already initiating the administration process themselves.
Wow.
So yeah, expect more formal appointments quite soon.
Okay. A sobering picture on the legal front. Let's pivot directly to the impact on you, the loan note holders. What does all this administration stuff actually mean for your money?
Right. So these companies took your money via loan notes. Now they're in administration, a formal insolvency process, and that triggers specific legal steps.
Like what? What should people be looking out for?
The key thing, really, is that within 8 weeks of administration starting, the administrators have to produce 2 vital documents.
8 weeks.
Yep.
Okay. And what are these documents?
First is the statement of affairs. Think of it like a company's financial health check. All its assets listed, all its debts listed. It shows exactly where things stand, likely quite starkly.
And the second.
That's the administrator's proposals. This outlines their plan, what they intend to do, how they might sell assets if there's any chance of paying back creditors, and how.
So these documents will be the first real glimpse into the actual financial state.
Absolutely. They'll reveal the extent of the problem based on the administrator's initial findings.
Now, the elephant in the room.
How?
These loan notes were often sold as secured. People thought their money was backed by assets. What happens to that security now?
Well, it's critical. They were marketed as secured. But the early indications the intelligence we're gathering, it's worrying.
How so?
It strongly suggests the actual value of those supposed assets is, well, much, much lower than everyone's led to believe, potentially drastically lower.
And the implication of that is?
The practical consequence is stark.
Yeah.
Your low note debt will almost certainly be treated as unsecured debt in the administration.
Okay, explain that difference, secured versus unsecured in this context. Why does it matter so much?
It's fundamental. Secured creditors have a claim over specific assets. If those assets are sold, they get paid first from the proceeds up to the value of their debt.
Right.
But unsecured creditors, they're in a general pool. They only get paid after secured creditors and, crucially, after all the costs of the administration itself are covered.
So if the assets aren't worth much, or the security wasn't legally watertight,
then you fall into that unsecured category. And honestly, for unsecured creditors in situations like this, the outcome is usually, well, it means substantial losses are almost inevitable.
which really counters a common assumption, doesn't it? People hear administration and think, okay, someone's sorting out, maybe I'll get my money back.
Exactly. That belief is understandable, but the legal reality in the UK, especially for unsecured creditors, is often very different.
Because there's a strict pecking order for who gets paid.
Precisely. UK insolvency law has a very clear hierarchy, and guess who's at the very top?
Let me guess. Not the loan note holders.
Not even close. The administration costs themselves get paid first. Always. No exceptions.
And what does that actually include? What are these costs?
It's a lot. You've got the insolvency practitioner's fees, their time and work managing the whole thing, then legal fees, advisor costs, maybe fees for valuing assets, paying suppliers needed during the process, ongoing running costs. It all adds up very quickly.
So that pot of money from selling any assets shrinks fast before anyone else sees a penny.
That's exactly right. All those costs come off the top. Only if there's anything left after all that is paid does it then get distributed to creditors.
And for the unsecured creditors, like these loan note holders are likely to be.
The harsh reality is often there's very little or sometimes absolutely nothing left by that point, which really highlights why just waiting and hoping on the administration process alone is, well, it's a very risky approach if you want to recover funds.
It certainly seems that way. Now, what about the police investigation? We know the City of London police are looking into the 79th group. Is that a potential route for getting money back?
It's natural to hope so. And yes, the police investigation is active and important. But we need to be realistic about what it can achieve for investors financially.
Why is that?
These kinds of complex financial investigations take a very long time. Years, often. And even if they eventually lead to criminal convictions.
Which isn't guaranteed.
No, not at all. But even if they do, the criminal courts rarely order compensation to be paid directly back to the individual investors who lost money. Their focus is different.
So justice might be served in a legal sense, but not necessarily in a financial recovery sense for the victims.
That's generally the case, yes. The mechanisms in criminal court just aren't really set up for large-scale victim compensation in these complex fraud-type scenarios.
So the police investigation, while important, probably isn't the answer for recovering your investment.
If recovery is the main goal, then no, probably not. It means you need to look at civil routes, proactive steps you can take yourself, rather than relying solely on the outcome of the criminal process.
Okay, that makes sense. So if administration likely won't pay out much, and the police investigation isn't geared towards recovery, what can loan note holders actually do? What are the realistic options?
Broadly speaking, there are three main avenues worth exploring right now.
Three options. Okay, let's break them down. What's the first one?
The first is looking into bank refunds. Specifically, under the rules for authorized push payment fraud, APP fraud.
APP fraud.
Okay.
That's when you're tricked into sending money yourself.
Exactly. If you sent your investment money from a UK bank account to another UK bank account, you might be able to claim a refund from your bank.
Are there specific rules or dates for this?
Yes, there are two main schemes. The CRM code that covers payments made after May 28th, 2019, if your bank signed up to it.
Yeah.
And then there's the newer mandatory reimbursement scheme for payments after October 7th, 2024.
Okay. And what makes you eligible? Just being tricked isn't enough, presumably.
The core condition is being deceived into making the payment. For the older CRM code, your bank needs to be a member, and you needed to have acted reasonably carefully.
And the newer scheme from October 2024.
That one makes reimbursement mandatory for banks, up to £85,000 per scam, for payments between UK accounts, assuming you weren't grossly negligent.
85,000. That could help some people. But are there catches? Limitations?
Definitely. Firstly, it generally only applies to UK payments. International transfers are usually out.
Right.
Secondly, that £85,000 cap under the new mandatory scheme is per scam, which might not cover larger investments. Banks can also still reject claims, say if they argue you were negligent, or if it's disputed whether it was actually a scam.
And it's probably not quick either.
No, the process can take months. So APP recovery is worth looking into, especially for smaller amounts, but it often won't be a complete solution for bigger losses, and it has hurdles.
Okay. So APP refunds are option one. What's the second avenue?
The second relates to the Proceeds of Crime Act, or POCA.
POCA. That sounds linked to the police investigation we discussed.
It is linked, yes. POCA is the legislation that allows courts to confiscate assets bought with the proceeds of crime. So, in theory, if assets related to the 79th group are identified as criminal proceeds,
They could be seized.
they could. But again, relying on this for investor payout is problematic. The process is slow, complex, and getting seized assets distributed back to victims is uncertain and, frankly, quite rare in practice.
So, like the police investigation itself, POCA is more of a secondary factor than a direct recovery route for investors.
I think that's the realistic way to view it. It might happen in the background, but it's not something you can actively rely on to get your specific investment back soon, if ever.
Which brings us to the third option. You mentioned this might be the strongest. Third-party recovery, the strategy insolvency and law are using.
Yes, this is where we see potentially more direct avenues for recovery. The key difference is this strategy doesn't just focus on the collapsed 79th Group companies themselves, because, as we've said, there might be little left there.
So where does it focus?
It targets the professional indemnity insurance, PI insurance, of the regulated firms that were involved in advising on or promoting the investment to you in the first place.
Regulated firms, like
Right.
financial advisors or brokers.
Exactly. Firms that are regulated by bodies like the Financial Conduct Authority, they are required to have this PI insurance. It's essentially cover in case they give bad advice or are negligent, causing client losses.
Okay, but what if those firms aren't around anymore? What if they've closed down?
That's the crucial point. Even if the firm itself has shut its doors, the insurance policy they held while they were trading and advising you might still be valid for claims relating to that period.
Ah, so the insurance cover could still be accessible?
Potentially, yes. It's designed to cover past advice or actions, and this is where specialist help comes in.
You mean identifying these firms and their insurers?
Precisely. Insolvency and Law specializes in this. They investigate which regulated firms were involved, advisors, introducers, platforms perhaps, and then they work to access that potentially still active PI insurance to claim compensation for the investors.
So it's about holding those advisors or promoters accountable through their insurance.
That's the core idea, focusing on entities that had regulatory obligations and insurance backing, rather than just the insolvent company where funds may have disappeared.
Okay, so if someone listening thinks this third-party recovery route sounds promising, how exactly can insolvency and law help them? What do they actually do?
Well, Insolvency and Law are a UK firm. They're specialists in insolvency and recovery, but importantly, they work only for creditors.
So for the loan note holders in this case, not for the administrators.
Correct. Their job is to represent the investors' interests under UK law. They investigate the involvement of these regulated firms, dig into the insurance policies, and build cases to claim against those insurers.
Is it something people do individually?
They often coordinate group actions. So, bringing together multiple investors who were advised by the same firm, for example, this shares the cost, makes the case stronger, generally more effective.
And it's proactive rather than waiting for administration crumbs.
Absolutely. It's about actively pursuing recovery from potentially liable third parties and their insurers, not just waiting passively for whatever might be left over, if anything, from the insolvency process itself.
Right. So for everyone listening who holds loan notes in the 79th Group and is facing this situation, what's the single most important message? What should they do now?
The key takeaway is don't wait. Time can be critical in these situations. The best immediate step is to contact the specialist team at Insolvency and Law directly.
And how do they do that?
The easiest way is by email. Send the details of your situation to investigations@insolvencyonlaw.co.uk.
Investigations@insolvencyonlaw.co.uk.
Okay.
And what happens after the email?
Their team will review your specific case. They'll help you understand the options, particularly this third-party recovery route, see if it applies to your situation, and explain the next steps if you want to proceed.
So get in touch, get your situation reviewed, and understand your options. It seems like very clear advice.
It's about taking control where you can.
Absolutely. So the call to action is clear. Email investigations@insolvencyandlaw.co.uk. And perhaps, as a final thought to leave you with, while you're processing all this, think about your own investment journey. Beyond just the 79th Group itself, who else was involved? Was there an advisor? A promoter? A platform? Could they potentially bear some responsibility for the situation you now find yourself in? It's a question worth asking as you explore how to move forward.